Hello everyone, my name is Anne and I'm a summer intern here at Lyles Parker. Welcome to today's Webinar Wednesday hosted by the Texas Association for Home Care and Hospice. Today's webinar is entitled Home Health and Hospice Business Relationships. Is your agency in violation of the Anti-Kickback Statute, Starks, or False Claims Act? Without further ado, today's presenters are Robert Lyles and John Pierce.
Thank you very much, Ann. Ann, by the way, is from Texas, and she's looking forward to flying home tomorrow before she returns back to school at the University of the South.
Absolutely.
We're going to miss her. She's been a lot of help this summer. I'm here today with my colleague, John Pierce. Now, John and I were both assistant U.S. attorneys. I was an assistant U.S. attorney in the Southern District of Texas. Then I was the National Healthcare Fraud Coordinator for all the U.S. attorneys' offices in the country. John has a very extensive background. John was a federal prosecutor at the U.S. Attorney's Office in San Diego. Is that right, John?
Yep.
And then also in the Eastern District of Virginia and the District of Columbia. John has extensive experience working as a white-collar defense counsel, and we're lucky to have him at Lyles Parker. John also he represented the Eastern District of Virginia as their representative on the Attorney General's Healthcare Fraud Advisory Committee. So we're very lucky to have John with us today, and John's going to be talking about the Anti-Kickback Statute and what he's seeing with his, being on the ground and seeing the prosecutions taking place today. Great. Now, John, before we kind of get started and talking about the statute, I think it's helpful if we kind of discuss the environment, the enforcement environment out there. I mean, what's your take on this? Last year, these numbers look pretty significant, in my opinion, considering that the world was shut down last year. What's your take?
Well, there certainly continues to be a strong focus with the federal government examining healthcare fraud on the criminal side with home health care and hospice agencies. So I didn't notice any slowdown during COVID, and in fact, all of the government employees, whether they were working from home or going into the office, they seem to keep turning on, investigating these cases for fraud and targeting, particularly in Texas, home health care.
I think that's exactly right. And I think that it is important to kind of keep in mind that last fiscal year, the government brought in $2.2 billion under the False Claims Act. 1.8 of that was from healthcare, and a lot of that money came from cases out of Texas. We're going to talk about some of the current cases in Texas involving home health and hospice in this presentation. Let's go to the next slide, Ann. Before we kind of get into the Stark and the False Claims Act and the Anti-Kickback Statute, one thing is it's kind of helpful to kind of get an idea of how these cases are ginned up. And there's no question that under the False Claims Act, for instance, the vast majority of cases, at last count, it was about 89% or so, of all False Claims Act cases were originated from whistleblowers, not from, sua sponte, not from the initiation of the government itself. Okay, so with regard to the False Claims Act, most of these cases are coming up on the whistleblower side. But what about on the criminal side? Well, it's important to keep in mind that the government uses all these administrative contractors to do these audits. And some of these contractors, like the Unified Program Integrity contractors and the Supplemental Medical Review contractors, and even the state MAFUCUs. You know what a MAFUCU is, don't you, Ann?
Yes, sir.
That's a Medicaid Fraud Control Unit. The first time I heard that, I thought somebody was disrespecting my mother. But all of those folks, when they identify instances of fraud, under their contracts, primarily the UPICs and the SMRCs, they are required to make referrals over to OIG and DOJ. So, don't think that the administrative process is something that you can kind of ignore, because that's where a lot of these cases against home health and hospice are being ginned up these days.
Robert, if I could just jump in, that it's important for you folks to remember that whatever information, or as we lawyers like to call it, evidence, whatever is accumulated by a UPIC or any other entity with respect to your business is applicable in an administrative proceeding or civil proceeding, or in my bailiwick, a criminal proceeding. So whenever you get any contact examining any of the information that you have submitted to the government, usually claims, you need to consider right from the jump, should I contact my lawyer? Well, I don't know if any of you out there are old enough to remember that old commercial for Fram oil filters where you can pay $7 for a Fram oil filter now, or you can pay me for a new engine later. It's the same here. If you get any contact from the government inquiring about your submissions to the government, you should call your lawyer while it's going to be inexpensive to address, instead of waiting until later when they accumulate this information, particularly any statements that you make, and they hand it over to a criminal prosecutor in the U.S. Attorney's Office to bring a criminal case against you, at which time everything that you have said is evidence to be used in a criminal case. No need for Miranda warnings in that setting. So you can pay us now or you can pay us later, as Fram Oil Man says, but please contact your counsel when you first get contacted. Sorry, Robert, I interrupted you.
No, I'm glad you brought that up. And that kind of, I mean, it reminds me of something that my granddaddy, who was a Texas judge, I asked him one time, I said, Grandpa, what was your area of focus? And he said, whatever your problem was, that was my specialty. And the point is that I'm trying to make here is you do need to contact your attorney, but make sure that it's a bona fide, qualified healthcare attorney. Okay, not the attorney that handled some physician's second divorce. I mean, you want to get someone that does this day in and day out, because this is a very unique area of the law. And as we're going to talk about today, especially in the area of the Anti-Kickback Statute, business practices that are perfectly legal in any other industry are likely illegal in healthcare. Next slide. Now, I thought this was really interesting, John. The strike forces out there. What jumps out at you from this?
Well, look at the regions. I mean, most of them are focused in big city areas, but Texas, there is a huge focus on what the government believes is fraudulent conduct in Texas. So the eyes of Texas are upon you. You cannot escape the government's view. There's a lot in Florida, there's a lot in Louisiana, but there's a huge focus in Texas with these government strike forces, and it's because, going back to your point earlier, Robert, about it's all data driven, they're finding that the data tells them we are getting claims in Texas at a high volume that are suspicious to us. And so we need to create task force for these particular regions. So that's what jumps out at me.
That's right on point. And in fact, in Texas, the last data that I reviewed, the average expenditures per Medicare beneficiary are the highest in the country in South Texas. Well, that's something that the government looks at. Where they're spending their money is where they're going to want to put a lot of enforcement of review resources. So, got to keep all that in mind. Now, this is something else that I think is really important, and I'm going to ask John to kind of cover this. But what jumps out at me here, the folks on this line probably remember at the very end of the Bush administration, beginning of Obama, we had all of those horrible financial problems, and the banks were going belly up left and right, and it was just a huge financial disaster. One thing you'll remember as well, though, I doubt anyone on this call can name a single individual that was prosecuted for those crimes. Not a single one. One of the things that changed, though, of course, is when the Obama administration came in, they made a lot of I don't really think it was a sea change in the sense that I think that DOJ always looked at individual culpability, but there's no question in my mind that they really kind of memorialized that or made that, something that was official. John, can you kind of touch on this?
Well, let me give you a little bit of historical perspective here. Of course, we learned in law school that a corporation is a person in the eyes of the law. So for years and years and years, big corporations with lots of money that could hire really expensive lawyers would have those lawyers negotiate with a government prosecutor's office investigating the corporation for misconduct of some kind. And they would swing a deal where, well, let's have the corporation enter a plea of guilty and let all of our officers and board members go. And it was happening all the time. So corporation would plead guilty, they'd get a $300,000 fine or a $1 million fine or maybe even more, but there would be no implications against an individual. And of course, we all know that it's individuals in the corporation that are making the decisions. So the Yates memo basically instructed prosecutors in the US government around the country that, look, let's not pretend that there aren't people that are committing the crimes within a corporation when the corporation commits a crime. So you're going to have to find the people and hold them responsible and accountable, and not just enter into these deals where the corporation takes a hit and everyone goes on in their lives, despite the fact that that these individuals may have ruined many other people's lives by financially ruining them. For instance, as Robert mentioned, in the banking industry with all the home loans and whatnot that went belly up, no single individual was ever prosecuted for conduct that, if you recall, literally changed the economy of the world. Not one person. So that's what the Yates memo addresses. And they're using it full force in healthcare, I'll tell you that.
They are, and I think it's also notable that Sally Yates, of course, when the Trump administration took over, Sally Yates, for a short period, was the acting attorney general, and President Trump, of course, fired her. Now, you would think that if he's going to fire Sally Yates, that he's also going to be very, very critical of whatever she has put in place. But they never revoked the Yates memo. In fact, they have built upon it since she left the department. So this is still the rule of the land, and I think that everybody on this call in the home health and hospice industry would recognize that they're going after, and as we're going to go over these examples, they're going after the owners, they're going after the managers, the marketers, everyone that's in any type of administrative or ownership or business really position who is involved in the crime. They're holding them accountable. Now, just to kind of step back for a second, there are a lot of other things that are going on. We're seeing lots of the post-payment audits, as we discussed. The UPICs are very active. Their suspension actions are taking place left and right. They are excluding people. Last year, they excluded more than 2,100 individuals and entities. Okay, now this is really important, guys. Everyone on this phone call, you're in Texas. And when you, and many of you take Medicaid, in fact, probably most of you take Medicaid. Well, in Texas, you actually sign, as part of the participation agreement, you sign a requirement that you are reviewing your agents, employees, contractors, and vendors every 30 days against all federal and state exclusion lists. So if you're not doing that, guys, you got a real problem. Next slide. Now let's get into the False Claims Act. John, I know you do a lot of work in the False Claims Act as well as the criminal side. Would you like to kind of comment on the False Claims Act?
Well, let me again just add a little historical perspective. I'm not sure if it's on this slide or the next one. No, here it is. Yeah, Lincoln's Law. So the whistleblower law, the Ketam law, as it's known in Latin, emerged from the Civil War when, let's just take, for instance, Grant may have been moving troops through Pennsylvania, and he needed to camp overnight on a farm, and he goes to the farmer's door and he says, look, I'm gonna need 10 head of your cattle to feed my troops. Just send the bill to Washington. And then the farmer may submit a bill for 20 head of cattle. Well, there's no way that the government, particularly at that time, could keep track of when it was being fleeced and when it wasn't. And the only way it could be able to know that is to get the citizens to volunteer information that they knew from the inside. So the next door neighbor of the farmer could go down to Washington or send a telegraph and say, hey, he charged it for 20 head, but they only used 10. So you're getting fleeced. So that was the origin of the whistleblower laws. And so now, in its current application, anyone, particularly in healthcare, because that's where the False Claims Act really lives. There's so much more healthcare false claims prosecutions, whether civil or criminal, than there are anything else. And that's where a whistleblower, usually from inside an entity, will say, hey, my boss is charging for this home health care, and my boss isn't sending anyone out to actually see him. So government, you're getting billed for services that aren't even being performed. So that's where the False Claims Act lives now, at least as it applies to you. It's claims that can be brought on the government's behalf to say, government, you're not getting what you paid for. Robert?
Yep. And, you know, it's important to remember, under the False Claims Act, just very simply, if you knowingly submit or cause to be submitted a false claim to the government, you can be liable for damages and penalties, okay? Treble damages, in fact, and significant penalties. And you may say, well, John, but I would never knowingly submit a false claim. But under the statute, they made it very broad. It's actual knowledge, reckless disregard, and deliberate ignorance, okay? So that's pretty broad. And in fact, under the False Claims Act, it's got a long tail in the sense that it's got a huge statute of limitations issue there. You know, most criminal cases, most federal criminal matters must be brought within 5 years, unless it's a continuing fraud, in which case they can go back even further and bring other things in. And then there are some exceptions, of course, for some securities and banking areas. But for the most part, it's 5 years. Under the False Claims Act, it's 6 years, or 3 years after the government learns about it, up to a maximum of 10 years. Okay, and the penalties, as we indicated, they're very broad. I mean, just to kind of show our age here, when John and I started handling these cases, it was $5,000 to $10,000. Now, of course, it's $11,800 to $23,000. So I mean, the problem with the False Claims Act is, and the reason why you see so few of these cases ever brought, okay, is that it's like the sword of Damocles hanging over a provider's head. When the government can get up to $23,000 per false claim plus treble damages, it adds up very fast, and you're into the multi-millions in a blink of an eye. Next slide.
And in that regard, Robert, when they say that's the amount of a fine for a false claim, your claim may be for $100, but you're looking at, you know, $11,000 to $20-some thousand as a fine for that act.
That's right. That's right. Okay, just one more thing. We're going to be talking some more about some of these cases, but many of you may have heard the Escobar case, and it was heard by the Supreme Court. And the reason why this is an important case, you know, is that the Supreme Court ruled that if you stay silent about noncompliance, okay, that can constitute fraud under the False Claims Act. You know, so basically, you know, Senator Grassley, the way he described it, it goes without saying that a lie of omission is still a lie. Okay, so that's why it's important. Even if you're saying, well, I haven't, submitted a false claim, if you know of conduct that might give rise to false claim liability, for instance, we're going to be talking in a few minutes about kickbacks, okay, that could give rise to false claims activity just because under the Affordable Care Act, we'll talk about that in a minute, but that could be a false claim. Now, briefly, we're going to talk about Stark. Stark is extraordinarily complicated. It was named after Congressman Pete Stark, and essentially what Stark is, the whole purpose of Stark, it started out in the clinical lab area, and it was to prevent a physician from essentially self-dealing. They didn't like the fact that a number of physicians may have bought into clinical laboratories, and they were making prescriptions or they were sending orders out to labs in which they had a financial interest. So the purpose of Stark was to stop these self-dealing situations because they were afraid it leads to overutilization. The problem, of course, is that just like any of these statutes, I mean, once you apply it to the healthcare arena, it gets very complicated very fast. Now, Stark only covers things that are known as designated health services. And here's a list of the designated health services. You'll notice hospice is not here. Okay, so it's you don't typically see anybody spending a whole lot of time worrying about Stark with respect to hospice. I mean, they spend almost all their time worrying about the Anti-Kickback Statute and the False Claims Act. But home health services are, in fact, a designated health service. Okay, and that's why we have so many problems with doctors having an ownership interest in a home health agency, if in fact he's going to be sending referrals. So that can be very problematic. Okay, Stark is a strict liability statute. It's civil in nature. It can result in CMPs, refunds, exclusion, and it can give rise to False Claims Act liability. Okay, now the reason why I say you need to be very careful with Stark is it is so incredibly complicated. There are literally thousands of pages that have been issued trying to kind of decipher and put their arms around Stark. And, there was the phase 1 proposed rule, the phase 2 rules, the phase 3. In 2015, they came out with more proposed changes. And then most recently, last November, they issued a final rule with additional changes to Stark. And that just kind of gives you an overview of all the different times that Stark has changed. For our purposes, though, one thing to kind of think about, and this is the case with the Anti-Kickback Statute as well. Stark is so broad that Congress recognized that there are some business arrangements that don't necessarily constitute a significant financial risk to the Medicare program. And they said, well, in those cases, you can have what are known as exceptions, okay? And an exception would be, well, if these requirements are met and you have to have, it's basically strict adherence to the requirements. If you meet certain requirements, then it would not constitute a violation of Stark, okay? Some of the things to kind of keep in mind with Stark I mean, the law out there has made it very clear that compliance with Stark is a prerequisite to payment. And if, in fact, it's a violation of Stark, that can give rise to a False Claims Act case. Another thing that comes up a lot, there are two terms that you'll hear a lot with regard to Stark and the Anti-Kickback Statute. One is fair market value, and the other is commercial reasonableness. And, the question is, what is fair market value? And essentially, fair market value is, what would be the value of a certain service or an asset if, in fact, no referrals were going to result from that transaction. In other words, if you're going to purchase services from someone and that individual or entity is not providing any referrals to you, what would be the amount that you would pay? That would be fair market value. Commercial reasonableness is an arrangement that appears to be sensible and is a prudent business agreement from the perspective of the parties, even in the absence of potential referrals. So when it comes to both of these things in commercial reasonableness and fair market value, the way the government looks at this is, if there wasn't a business relationship between the parties in terms of referrals going back and forth or one way, how much would one party pay for the services at issue? Okay? Because if it's a different amount for someone that is actually sending you business, then the government says, well, obviously you're paying more than fair market value. And if you're paying more than fair market value, the only reasonable conclusion would be that you're paying for referrals. Okay. So just to kind of summarize, home health services are DHS. Very important that you check out any of your ownership relationships and make sure that if there's a physician involved or you've got a business relationship with a physician, you got to make sure that that business relationship does not violate Stark. Okay, John, this is really, I think, the most important portion of what we're talking about today, and that is the Anti-Kickback Statute.
Yeah, so I think all of our attendees know this, but the Anti-Kickback Statute in its essence is, we don't want there to be a financial reward for a doctor's decision. So we don't want medical decisions being influenced on an amount of money that somebody might get as a result of making that professional decision. So outside of the home health context, but just as an example, if a physician were to make a deal with a lab that says, every blood test that I send you, I'll send you all my tests if you'll pay to me everything over $150 that you receive. So I'll get you all these $150 pieces of business, but if you get paid $300, you got to send me the other $150. So that would influence a physician's decisions on what kind of tests to be ordering, how many to be ordering, if he or she was going to be getting that kind of benefit. So we have the anti-kickback laws, and as the slide shows here, originally it was just a misdemeanor. It didn't have that much teeth. And then in short order, 8 years later, in 1980, they ratcheted it up to a potential, oh, I'm sorry, Robert, I may be misreading the slide. I think that's where they made the change for the knowing and willful requirement to the conduct.
Exactly.
At some point, they ratcheted up to a felony. I don't know if that's your next slide or not.
Yeah, it is. It was a felony. There was an interim step in there where it did switch into or switch from a misdemeanor to a felony. But really, I think the next big transformation of the statute was with the passage of the Affordable Care Act. Because before they talked about, the statute actually says under the Anti-Kickback Statute, it's a crime to knowingly and willfully solicit, receive, offer, pay any remuneration. That means anything of value in return for, and then they have this list. Under the Affordable Care Act, though, they said, well, yeah, but, and see, here's the problem. When in 1980, they threw in the words knowingly and willfully, they didn't really define them at that time. And over the next, let me see, this was passed in 2010. So over the next 30 years, the circuits were all over the place. as to what does that mean, knowingly and willfully. And some circuits said you had to have actual knowledge. Some circuits said you didn't. You know, there were real questions about what constitutes scienter, what constitutes intent. Well, they tried to address that under the Affordable Care Act. And they said, as part of the Affordable Care Act, they said, okay, we're going to leave the statute reading like it does, knowingly and willfully, but you don't have to have actual knowledge and you don't have to have specific intent. That's scary, in my opinion, because that waters it down to where the prosecutors can try to bootstrap you in for practically any conduct.
It's in the criminal context, we call it deliberate ignorance, where somebody could have actual knowledge, but knew, frankly, that if they inquired, they wouldn't like the information that they received, so they deliberately ignore the information. And this is just an example of, in that context, they have made that the level of intent necessary to prove the case. It's used in the same context. Again, this is outside healthcare. It's outside home healthcare. But at the border, if somebody's putting a few kilos of cocaine in your trunk as you're driving across, and you turn your back because you know that's what they're going to do, and load up your trunk and you drive across, and the fact that you said, well, I didn't know, it doesn't work if the government can show, well, the only reason you didn't know is because you deliberately ignored the opportunity to know, and that's going to be sufficient intent in that criminal context as well. Robert?
And you know, there have been some other changes under the Anti-Kickback Statute. Now, instead of 5 years in prison, well, it started out, of course, as a misdemeanor. Then it went up to 5 years in prison. And then most recently, it was changed to 10 years in prison. And they increased the amount of the criminal fine from $25,000 per violation to a $100,000 violation. And then I think it's also important to kind of keep in mind that they also made it to where, under the Affordable Care Act, that a violation of the federal criminal anti-kickback statute also now constitutes a violation of the Civil False Claims Act. And we'll talk about that in just a second. Now, that really, it's just amazing to me that they did that. Why do you think that they would do that? I mean, to be clear, they were already bootstrapping False Claims Act cases off of anti-kickback violations in earlier cases before 2010. But why do you think, John, that they made this change in the law to make it where it automatically constitutes a violation?
Well, I think, are you talking about the deliberate ignorance, why they expanded the definition of intent?
Or the fact that now a kickback violation can be pursued as a violation of the False Claims Act?
Well, because in the theory of a false claim, if you have gotten business that you would not otherwise have gotten by paying a kickback, and as a result of that business, you, whether you provided a service or not, developed a claim to the government that would not, or potentially would not have happened. The government wouldn't have suffered that expense to provide, to pay for that service if you hadn't greased the wheels to make the service a possibility. They're going to consider that a false claim. The government's been expanding the definition of what it considers a false claim. And just to go back on something that I neglected to mention about the origin of the False Claim Act, when we called it the Lincoln Law, the idea there was that if a citizen knows something and reports it to the government, something the government wouldn't otherwise have known, they get a reward for that, and they get a percentage of what the government recovers. Well, and that's why the main point here is that the fact of the matter in all your businesses is that there are whistleblowers everywhere. That's why you got to, operate on the up and up. You got to have good counsel helping you operate on the up and up, because there will be a whistleblower somewhere along the line, whether they work for you, whether they have information about your business, that will report improper conduct. And if that improper conduct is paying for business, paying for referrals of business, then the government is going to say, you know what? You wouldn't have gotten that business if you hadn't have paid for it improperly, and we're not going to pay for it if you're getting your business improperly. So that's why they've expanded the False Claims Act to include that conduct, and that's the exposure that all of you out there listening face with the expansion of the False Claims Act to include anti-kickback conduct.
Okay. All right. Now, just like we discussed very briefly with Stark about how the fact that Stark is so broad that they had to create these exceptions, it's even more so with respect to the Anti-Kickback Statute. And once again, the Anti-Kickback Statute it's as wide as it is long, extraordinarily broad. And Congress recognized, not every business arrangement, even though technically it might constitute a violation of the Anti-Kickback Statute, but we don't really want to stop every business arrangement as long as it doesn't really, represent a risk to the financial integrity of the Medicare program. So what they did was they created these safe harbors. And a safe harbor is a list of requirements that, if met, would not then you would not be in violation of the Anti-Kickback Statute. Now, unlike Stark, the Anti-Kickback Statute, it's not a strict liability situation. In other words, just because you don't meet all the requirements under the safe harbor, that doesn't mean necessarily that you violated the law. But if you want to get the protection of the safe harbor, then you have to meet all of those requirements. Now, at some point, it almost feels like the safe harbors or the exceptions are really going to swallow the statute, because right now, with the new safe harbors that went into effect in January, we now have 11 statutory safe harbors and 36 regulatory safe harbors. Now, statutory safe harbors are safe harbors created by Congress. Regulatory safe harbors are safe harbors that went through the rule and comment process, and through rulemaking, they have created these regulatory safe harbors. So there's a lot there. Okay, for home health and hospice, of those 47 safe harbors that are out there, the two that you guys are really going to deal with most often are really the personal services and the employment safe harbor. Okay, that's really, now you may also, if you're talking about physician ownership of home health or hospice, then you may also have the small entity investment safe harbor. But for the most part, for the people on this line, it's the personal services and management contracts and employment safe harbor. Okay. All right, so let's talk first about the employment safe harbor. Now, the employment safe harbor is fairly straightforward. If you have a bona fide employee, okay, then the term remuneration, which means anything of value, does not include any amount paid by an employer to an employee, okay? Any amount. Now, I will tell you, prosecutors don't like, even though it says any amount, okay, prosecutors don't like these compensation arrangements where you're paying your people a percentage or you're paying your people based on their ability to generate referrals. For instance, let's talk first about the marketers, because you don't typically have, your physician relationships with your medical directors, they rarely ever would come under the employment safe harbors because you're not employing them as employees. They're almost always going to be an independent contractor, and you're trying to fit them under the personal services safe harbor. But even with the employment safe harbor, we've seen cases where, even though it says any amount, if you're a home health agency and you've got marketers and you're paying them based on their production, which would be perfectly legal and appropriate, and probably, it's the American way, frankly, to compensate people based on their success, right? I will tell you that prosecutors still don't like those types of arrangements. And I am currently working on a case, and I've seen many other cases where the prosecutors would come in and they would really say, well, we don't think it's a bona fide employee. Okay, so you can see how this gets pretty sticky, because even if you think that it's okay because it's an employment safe harbor you're trying to meet, if the government comes in and they challenge whether or not that really is a bona fide employee, you're going to be on the defensive to show that it meets those criteria. Okay. Now, I thought this was a pretty good example of what we're talking about here. This is a Fifth Circuit case, not home health, not hospice. It was a DME company, but it really lays out the issues. John, do you want to kind of talk about some of these factors that they looked at when they were trying to decide whether or not this was an employee versus a non-employee?
Well, first, for you non-lawyers out there, the Fifth Circuit includes Texas, and that's why this was picked. So the and let me also note that the same conduct in healthcare that can be viewed for administrative proceedings or civil proceedings can also be analyzed for criminal proceedings. And so the same conduct that might be prosecuted in criminal court in one courtroom could be pursued as a civil case in another courtroom. When it comes to things like the safe harbors and the exceptions, that gets very nuanced, and it's unlikely that a criminal prosecutor is going to pursue conduct where there's an enormous number of analyses to make about whether it fits in this part of the statute or that part of the statute. So that's really going to be analyzed in the context of a civil proceeding or an administrative proceeding. But it gets back to that same Fram oil filter analogy. Get your lawyer involved early. You don't want to end up in any of those proceedings, and you can iron it out in advance to avoid the problems. Now, Robert, you want to hit me with that question again, please?
Yeah, in this particular case, they were looking at, is this marketer who was paid on a commission basis, if it meets the safe harbor, the employment safe harbor, and it's a bona fide employee, that compensation scheme is perfectly legal. But if it doesn't, it's a problem. And some of the things that the court looked at here, where you provide them regular paychecks. I mean, there's the obvious stuff of, was this person a W-2 employee or 1099 employee? Well, that only gets you so far, right? Then they're looking at, did they get regular paychecks? Did you provide them training? Did you give them money for marketing? Where did they get their leads from? Did you have regular office hours with these people and provide them guidance? The other side of that coin is, or were they pretty much on their own? And you only gave them checks when they succeeded in generating referrals. So this whole issue of a bona fide employee is one that gets pretty sticky. But that's what it's coming down to these days in a lot of the cases for both home health and hospice, if you're employing marketers. So I will tell you, yes, sir.
I was going to say, let me provide a little bit of context on this heightened analysis. Now, this is not in the home health business, but in, for instance, the addiction recovery business. there has been a huge focus on the marketers that are referring the patients to those treatment centers. And there was this huge evolution of business models where you have the late night commercial, are you suffering from addiction? And, call this 800 number. And that 800 number is going to be fielded by marketing companies who are going to, let's say, pre-qualify, ask certain questions about, do you have this condition? Are you facing these circumstances? Blah, blah, blah. They go down their checklist, and then they sell that referral to one of these treatment centers, who then contacts the person and says, we understand you're inquiring about treatment. And that's how the recovery centers were expanding their patient base, was through these marketers. And the government believes that this form of marketing is basically creating treatment that is not otherwise necessary. And so they don't want people getting paid a percentage of what the government might pay for treatment in that setting, just by soliciting the information from somebody and then selling it. They're okay if the treatment center has a bank of employees, and even if there's an 800 number that makes a referral straight to the employees, who are then doing a pre-screening and figuring out, well, is this do we have the appropriate services for this potential patient? That's okay. But if it's just an outside marketer who's going to be making a buck off of a percentage to make the referral, they're much more likely to fabricate the information about what the patient's actual circumstances are. They're much more likely to exaggerate because they're incentivized by a piece of the action. It's just like, the doctor who's getting paid a fee for making referrals to a lab. That doctor is going to be incentivized to order tests that aren't necessary, and the government is going to be paying for services, whether in the home health situation, whether in the drug treatment situation, whether in the lab situation. The government's going to be paying for services that weren't ultimately necessary because of the condition wasn't being analyzed by the person in the health industry who's appropriate to make the decision. And these outside marketers are going to be manufacturing expenses for the government in the eyes of the government. Robert?
Yeah. And I think that's exactly why the prosecutors are very leery of even what we would consider to be bona fide employment situations if you're paying your marketers based on success. I mean, it seems like the American way and all, but in Texas especially, there have been a number of cases over the years that we've seen where what happens is these employees that are marketers, they go to a physician's office, they strike up relationships with someone that works for the physician, because many times, frankly, it's not really the physician that drives where someone's going to be admitted for home health. A lot of times it's someone on the administrative side that will go to the doctor and say, hey, can you sign off on, if this patient's going to go to home health, can you order it? And this is where we would like to refer it. And we've seen situations where the marketer was actually giving money to an administrative person working for the ordering physician. So the ordering physician didn't know it was going, that a kickback was being paid. The home health agency didn't know that a kickback was being paid. And you can see why you really, if you're going to have marketers, and most of the people on this line do, whether you call them a community liaison or a marketer or whatever you're going to call them, educational consultant, whatever, you've got to keep a tight rein on their activities. And you've got to make sure that they're not out there engaging in conduct that's going to put your company at risk. Now, we've talked about the employment safe harbor. Let's talk now about the Personal Services Management Contract Safe Harbor. This is the one that really comes into play with your medical directors. And I will tell you, prior to January of this year, many of the medical director agreements that were out there were problematic because they were paying these doctors by the hour, and that was not necessarily consistent with all the strict requirements of the safe harbor for personal services. There were some modifications to this safe harbor, and they tried to kind of deal with that problem. And they said, under the modified rule, that you only really have to identify the methodology that you're going to determine compensation for, and it's got to be set in advance. Okay, that's one of the requirements. It has to be in writing, signed by the parties for more than a year, and the methodology has to be set in advance. Well, that made it to where the hourly was okay. But one of the things that did not change, okay, if you go down there at the very bottom line there, it's in blue, the compensation agreement cannot be determined in a way that takes into account the value or volume of any referrals. So you still can't give a medical director any kind of piece of the action. You can't pay them for, X number of referrals. You can't give them a percentage of monies that are generated. None of that works, okay? And the other reason, or the other requirements that are there, if we look at the very last bullet, it still has to be commercially reasonable, and it's got to meet fair market value. So all these concepts are still in place, all right? And so, I've seen numerous situations in Texas where a medical director is getting a flat fee, $2,000 a month. Okay. What do they do for that $2,000 a month? Well, it turns out that they go to a local steak place about once a month and they pick up their check. That's a problem, okay? If there's ever an audit, the first thing the government always looks at is where do you get your business from and where do you send business to, okay? So if that doctor, that medical director is someone that sends you a lot of referrals, they're going to want to know, well, that $2,000, that may not seem like a whole lot of money, but is it reflective of fair market value? What did he do for that $2,000? And the problem is, many times the medical director agreements that we see, they're not really detailed in that they don't require the doctor to log their time, to describe what they're doing, and show, retrospectively that, okay, this is how much time I've spent. And that's why I'm worth $2,000 a month, because on the average, I spend, let's just say, 8 hours a month at $250. That assumes, of course, that the fair market value for that type of doctor is $250 an hour. It may or may not be, depending on your geographic area. But that's why it's so important that you document all this, because if the doctor can't document, if you don't have the documentation from your medical directors, what they've been doing to get the money you're paying them, well, the government prosecutor is just going to conclude, if there's no evidence that he's providing $2,000 worth of services, what are they supposed to think? They're just going to jump on this idea that you're paying them $2,000 for the referrals. Now, in a perfect world, you would have a medical director that didn't send you any referrals at all. That's a perfect world. But that's probably not real life for most of the folks on this call.
Okay. Robert, if I could just make a quick observation, whether it's an agreement for your medical director, or whether it's a marketing agreement, if you get provided a document from somebody that you're doing business with or want to look at doing business with, and that person says, yeah, my lawyer did this, it's all been vetted, everything's on the up and up, it's okay, have your own lawyer look at that, please, because I can't tell you how many cases we have had where our client says, but my counterparty told me that everything was in order with this agreement. And when we start looking through it, it becomes clear that somebody grabbed this agreement from some other application and they just changed a few words here and there, and it does not protect our client. So please, if you're given anything and told, my lawyer's already looked at it, it's fine, please have your lawyer look at it so you don't get into trouble later.
That's right. That's right. Okay, we already talked about commercially reasonable. We're not going to spend. Let's talk about some of the cases in Texas right now. This first one, owner of a hospice agency, and the reason why I've got some of the stuff highlighted in red is I want you to see who they went after. Okay, the first case in the North Texas, they went after the owner for conspiracy, and they alleged that he was paying doctors $150 for each false order that they signed. Okay, well, you can't do that. That's first of all, it's not it's not medically necessary, and there's no way that meets any of the safe harbor requirements. The Southern District of Texas, that's down in Houston or down in the Valley. Government investigation of an agency found that a Houston physician had certified patients for home health services without any knowledge of the patient's medical condition or homebound status. So they went after the doctor in that particular case. Now, this is just the case against the doctor. Believe me, they didn't let the home health agencies just sit there. They went after them too. But I wanted to focus on the fact that in this particular case, the doctor had to pay almost $500,000. Another case, I think this one was out of the Valley as well. They went after the operations manager of a chain of hospice and home health care cases. He got 27 months in prison, had to pay ordered to pay $4.7 million in restitution for his role in falsely convincing thousands of patients with long-term incurable diseases that they had less than 6 months to live. So this is a situation, it's especially bad, where in this case, they alleged that the operations manager was involved in this scheme to convince people that they had less than 6 months to live, and therefore they should sign up for hospice. Well, the problem, of course, is once a patient signs up for hospice, they're no longer eligible for curative care. They can get palliative care, sure, but they're giving a lot up. So it's just horrible because it really takes advantage of the patients, and of course it's fraud against the system. Another case here, Southern District of Texas, the owner-operator of a clinic was paying doctors to approve patients for home health regardless of whether or not it was medically necessary. And in this particular case, they were, this clinic, they had patients coming in and they were getting exams from unlicensed individuals who were posing as doctors. The defendant got 25 years. John, one thing, we were talking about another case that you and I are working on in another part of the country, and you had some interesting observations about Texas that I wish you would share with the folks.
Well, for instance, I was chatting with a prosecutor from Houston just yesterday, and she was commenting to me, she goes, we don't really understand why, but Houston seems to have a huge volume and huge percentage of fraudulent home health agencies. So there's a very close focus on home health agencies in the Houston area, but frankly, I think all over Texas. And in this particular investigation, they set up a sting operation where a clinic posed as selling the signed certifications from doctors for the home health care, and it was phony. It was a doctor who wasn't treating the patient, didn't set up the nature of the care necessary, and so on this reverse sting, they roped in all kinds of home health agencies, and they're prosecuting all of them.
Yeah, it's a mess. There is a lot of focus in Texas, and I will tell you that the sentences in Texas have been extraordinary. I think significantly higher than most other areas of the country for similar conduct, frankly. You and I were looking at a case recently out of Montana, I believe it was, yeah. And they only got, I don't remember how many months they got, but you commented, well, if that was in Texas, it would have been 25 years.
Yeah, I read the statement of facts and the amount of loss, it was in the millions, the multi-millions, and for whatever reason, the federal judge in Montana gave a slap on the wrist of 9 months to one person, 12 months to another. And those same facts would render a sentence of years upon years in Texas.
Yeah, yeah. Now, John, you went to UT for law school, didn't you?
I sure did.
That's a good man, I'll tell you. Okay, next slide. We're running out of time here. Some of the things to watch out for, guys. Whenever you enter into a business arrangement, have your lawyer look at the business arrangement. That's where these things always leave the rails. The government, when they have a problem, and remember, how do they find you most of the time? It's going to be because of data, okay? Because the government doesn't do a whole lot real well, but one of the things they do extraordinarily well is collect data. And they've been collecting utilization data for Medicare since 1965. They pay all these contractors to go through and slice and dice the data and identify outliers. Okay, so, you know, at some point, you're going to be audited. It's going to happen. You're going to be an outlier in one category or another. Have your arrangements looked at, okay? Before you engage any type of a medical director, have that medical director agreement looked at carefully by someone that understands what the rules are. Make sure that if you're audited, that you're going to be able to support what you're paying in terms of fair market value, commercial reasonableness, and that it's not going to be problematic. Okay. One more. Let's just go back to one thing here. This is something that comes up a lot, and I know it still happens in Texas because I talk to people about this all the time. You know, the old days of dine and dash are over, and you know that may be gone. But the fact is, a lot of home health agencies and a lot of hospice agencies, unfortunately, still. They will go to their referral sources, the doctor's offices. They'll drop off a bunch of goodies for lunch, all these types of things. And they say, well, it's okay. Well, look at the Anti-Kickback Statute. Nowhere in there does it say you can drop off donuts or anything else for that matter, tamales. It doesn't say you can't drop this stuff off. I'm telling you, there is no de minimis requirement under the Anti-Kickback Statute. Okay, so now, do I really think the government's going to go after you because you give a fruit basket to a referral source for Christmas? Well, I think it's highly unlikely. But I can still tell you that if that's someone you get business from, that it's going to be, it could end up being on an indictment. I had a case one time. Well, I was giving a presentation one time, John, and I had this arm go up, and this lady stood up and she said, my husband's a physician. Are you suggesting that his integrity could be bought with a bucket of chicken? And I said, well, no, I'm not suggesting it, but obviously the pharma companies are, because they don't just show up at my house and knock on the door and give me a bucket of chicken. The only reason why they drop food off, the only reason why home health and hospice agencies drop off food, whether it's donuts or coffee or whatever, is because they're trying to curry favor. All right? And that's the kind of thing that, frankly, is a violation. Oh, and one more thing. Go back just one slide. Under no circumstances, one thing that always sets off prosecutors, even if you're going to take a risk and give that fruit basket, never, ever give liquor under any circumstances. The government takes a position there is never a bona fide reason to give liquor to a referral source. All right, so let's kind of finish up. John, these are some of the things that we recommend that folks do. You want to cover these?
Well, I'll just go back to the frame oil filter. I mean, get your lawyer involved early and often. It'll be a lot more efficient and less expensive than waiting till later. Anytime there's any inquiry whatsoever from the government, you're much safer calling your counsel to get guidance, so that your counsel can speak for you and you don't create any evidence just by talking to people in response to questions that you're obligated to provide. Always keep your records orderly and maintain them so that you've always got them. If there's an inquiry that goes back several years, you have to understand and stay in close contact with your employees and know what conduct they're involved in, because you're going to be held responsible for it. You want to do your own investigations and understand your own entity. Make sure that everybody's reporting fully. If you ever need it, you can bring in outside assistance like a lawyer to conduct an investigation of any operations that are problematic. But if you keep on top of it for yourself, then the government isn't going to be learning anything that you don't already know if they ever come looking. And then finally, if there's ever any inquiry or if you're involved in any kind of an action, if it's an administrative proceeding, we want money back, the government tells you, or whatever it is, make sure that whenever you close that inquiry by the government, you're closing it for all things, whether administrative, civil, criminal, everything. Again, your lawyer will know how to do that. It's called a global resolution. Just be sure that you're working with your lawyer to protect you.
Great, great. Okay, and then this just, yeah, there we go. Let's just, and unfortunately we're out of time, but we'd be happy to answer any questions. Do we have any questions, Ann?
We have one about whether or not they will be able to receive a copy of the recording.
Yes, they will. Once this is finalized, we will turn it over to TAC, and TAC, I believe, puts it on their website for their members.
Awesome, awesome. All righty, that's
in the meantime, yeah.
Last question, and that concludes today's webinar.
Well, thank you, and John, thank you for your time. And guys, if you have any questions or you need any assistance with your home health or hospice or even personal care contracts or business arrangements, or you're going through an audit, don't hesitate to give us a call here. We'd be more than happy to assist you. And that's it for today.
Bye, everybody.